One of the fundamental battle cries of a more ethical election process is that voters should get to pick their politicians, not the other way around. So anytime politicians start cracking open a congressional map, especially in the middle of a decade, to do just that, you can almost guarantee that effort will end up in court. If it does here in Missouri, it's likely to find its way to the Missouri Supreme Court. So our next guest, joining us now on the record, is retired Missouri Supreme Court Judge Michael Wolff from our KSDK studios in St. Louis. Judge, it's an honor to have you with us. Thanks for joining us.
Good to be here. Thank you.
We heard some Democrats protest the very gathering and convening of this special session, arguing that there wasn't a quorum. There weren't enough politicians here to officially gavel in. If this special session really started without a quorum, are all the laws they pass here vulnerable to being struck down, or is that really more of a technicality?
I think that's something for the legislature to decide whether or not they have a quorum. I think courts typically defer to that, but they might have a serious objection.
On the initiative petition reform, we're hearing that Republicans want to force a majority vote in every county. Would that flat out violate the one person, one vote rule and how voters have had a chance to influence state laws or the state constitution?
It may. I've not seen anybody try that before, because what it means is that the voters in some districts will have more weight to their votes than people in other districts. So that certainly is a legal problem. But the real problem they have is in getting the voters to approve a diminution of the voters' opportunities to change the Constitution and change the laws by the initiative process. So they may have more of a political problem than a legal problem.
And if the legal problem does venture into that equal protection territory, does the constitutional venue, is it more, should it be argued in state court or federal?
Either way, if it's a one person, one vote challenge, that really comes up under the Equal Protection Clause of the United States Constitution. It could be in state court, it could be in federal court.
And on precedent, have you ever seen courts uphold an action like this before?
I've never seen an action like this before.
Do you see courts stepping in on this or brushing it off as mere politics?
Well, the Missouri Constitution has a number of provisions that are kind of guidelines to how the legislature conducts its business. So unlike the federal courts, which are reluctant to get into the details of legislating, our Constitution basically invites that.
You're one of so few people who could have this perspective, but do the judges who wear those black robes feel some reluctance to wade into these overtly partisan waters?
I think that people are respectful of the fact that there is a political sphere and there's a sphere of law. And the two intersect in the Missouri Constitution. For example, a statute, a bill, is required to have a single subject and a title that describes the subject. We don't have that in the federal system, but the court ends up being the enforcer of that. And so there you'll find legislative enactments being struck down by the courts where the courts feel that principle has been violated. So we do have much more intrusion into the legislative process in state courts than we do by having the federal courts supervising what the United States Congress does.
And I guess I'm asking you to offer an opinion here, but do you see a ripple effect happening if Missouri is able to change the voter participation in this state? Could you see that door opening in states across the country?
Well, there's about 30 states that have the initiative process. And most of them are states that are not southern or border states like Missouri. And so many of them have these provisions are pretty protective of the opportunity of the citizens to change their constitution and change their laws by direct democracy. And so I think that it's not likely to have a ripple effect. Every state has its own culture with respect to that particular avenue for the citizens. Some have no avenue for the citizens. Some have a fairly robust avenue, which we do.
I have previously asked Senator Eric Schmitt to answer to some of your columns, things you've written. He has on this program dismissed you as someone who journalists go to when they want an activist judge, I believe he said, or a judge with a liberal persuasion. I've never given you a chance before to address that claim. Would you like to address that?
Well, I try to confine my comments to legal precedent and to statutes as written, constitutional provisions as written. That they want many times, if reporters, when they call me, I will tell them that there's somebody else that they ought to talk to who might be more deep into the particular subject they're asking about. So I'm not particularly reaching out to do that, other than I really do have an interest in law and making sure we get the law right. Sometimes Senator Schmidt gets it right, sometimes he doesn't.
It's been described to me that cracking up Kansas City would not be a violation of the Voting Rights or the Voters' Rights Act. I think even Congressman Cleaver said as much. Is there some other legal grounds this could be opposed on?
Yes, I think the state constitution is fairly clear about redistricting, because the Constitution says that when the state receives the results of the census, and that's when the state finds out how many districts it has, then the General Assembly by law is to divide the state into the number of districts that the state has. So my view is that when means when, so it follows the census. And the framework for this was established in 1929 in a federal act called the Federal Apportionment Act, under which this kind of allocation to the states is done by a formula. So when we get our signal that the governor gets that there are, for example, 8 congressional districts, that's when the districting can occur. When they drew the Missouri Constitution back in the Convention of 1944, there were a number of people who wanted to have an immediate redistricting because the districts were way out of line. And they didn't opt for that because there'd be 4 more years and there'd be another redistricting. So they didn't want to do a mid-decade correction then. And they followed the pattern of saying, when you get a census result, that's when you redistrict. And that's really in part governed by federal law, because the permission to divide up the state in congressional districts is a permission that is granted by the United States Constitution and refined by federal statutes. The Missouri Constitution follows that form, that framework, by saying when you get the census, that's when you do redistricting. I think they're out of time doing it in the mid-course, and I think there probably will be a challenge to that.
I guess just my only question that I'm still curious about there, if the Constitution is vague or maybe even silent, or if it doesn't explicitly prohibit the timing of when they pick up that map pen and start drawing lines again, then what stops an ambitious legislature from asserting itself in a creative fashion?
Well, I think that people who wrote the Constitution were very aware that you could have kind of a chaotic situation if you said, well, let's just redistrict every time we have an election. I don't think anybody wants that. And they opted for this system where you do the redistricting after you get the census results. If you don't have the census results, you're inherently going to be out of whack, because the census is, at this point, 4 or 5 years old. Things have changed. And so normally in legislating, the legislature can pass whatever laws it wants to whenever it wants to. But here they're acting under the mandate of a federal statute, and they followed that form when they wrote the Missouri Constitution by saying when. And I think when you get the census, when means when, not 5 years later.